Thank you, Chris. Ladies and gentlemen. You good on the sound? Thank you. All right. So, welcome. I want to thank ElderWorks for inviting me and putting together this great expo once again. And this morning, we're going to talk about elder, you know, and so that when you leave today, hopefully your questions will have answered, and you'll leave the room with some new information that will help you and your family. So we're going to start with a kind of a survey. How many people get along with all of their family members? Okay. How many people have had fights with their family over money? Okay, so a few people have likewise had some fights with their family. Well, I'm here to tell you today that, as you probably know, fights with families over money are a pretty common scenario. And today we're going to talk about some of those famous families that fight over money. We're going to talk about how that relates to everybody, whether you're or you're not. For all of that. And, this is what I and my law firm and our lawyers, we do every day. Regrettably, we're embroiled in battles over families fighting over their money, trust, and the battles that go on in conjunction with inheritance and death or disability during people's lifetime. If you have a question, let me know, and we're going to get started. As Chris said, I lead the law firm of Peck Ritchey. We have offices in, Northbrook, Oak Brook, Lake Chicago, and we're able to meet with you either in those offices or, of course, on the phone or via Zoom. So, just mentioned the American Bar Association me a few years ago to write several books for them. One was this one, Don't Let Dementia Steal Everything, was written for non-lawyers. And everybody in the room probably has either heard of, maybe read a book or seen a movie that involves Scott Turow. Scott's a friend, and he was kind enough to write the foreword for my books. And I want to read it to you because, it's really, really, I think, applicable to everybody. Alzheimer's disease is one of the scourges of our time, and one whose toll on the country will only deepen with the aging of the baby boomers and the inevitability of increased lifespan. Curing Alzheimer's would probably do more than any single step to reduce healthcare expenses, and far more important, improve the quality of the life of elderly here and around the world. Alzheimer's disease, as you know, and dementia comes in a variety of different forms. My law firm is the legal education partner for the Alzheimer's Association here in Illinois. So I lecture for them and teach people about the law on Alzheimer's disease on a pretty regular basis. So, the reviews are in. While elder abuse is a trend, it's not our destiny, said Philip Marshall, the grandson of Brooke Astor. But look at these statistics. They're kind of stunning. If you read your newsletter that comes out monthly from ARP, you'll see that those statistics are increasing regrettably as well. 1 in 10 Americans over the age of 60 have experienced elder abuse. This correlates to 5 million seniors being abused on an annual basis. Seniors who experience abuse are at a higher risk of death, 300%, in comparison to those treated with proper care. And this number down here at the bottom, I think is old already, but seniors lose up to $36 billion each year to financial abuse. In my law firm, we see this type of financial abuse every single day. It often comes with loving family members, and it often comes by caregivers that are taking advantage of the people that they're brought in to take care of. So it's a problem. As you can see, those stats come from the National Council on Aging, and the recent stats indicate that every time we write a slide, numbers are already changing because it's a bigger problem than anybody dreamed. So, according to the census, the 2020 census, that's 60 and over, and was boomers are aging, and population is growing older. We need more adults in growing number single day of the week. So in Illinois, we have an organization called, and the 2023 report, almost 21,000 reports of neglect, exploitation, and abuse were received by the Adult Protective Services Agency. Nearly 25% of the reports were for financial abuse. Most of the abusers were family members, and over 70% were children, spouses, or another relative of the victim. 61% of the victims were females, so disproportionately women are preyed upon in a higher number. All right, so stars, athletes, and entrepreneurs, famous celebrities, athletes, entrepreneurs. We've read about them and wonder how it happened to them. Well, it happens to them and it happens to us on a regular basis. So, Jim Morris. Anybody ever hear of the Doors? Jim Morris? Virtually everybody in the room raises their hand on that one. Morrison, at the age of 26. Assume why, but nevertheless, he had a 2-page handwritten will, basically a simple will. His entire estate was left to his girlfriend, and if she had died, to his brothers and sisters. Jim's girlfriend died without a will, so Jim's estate and interest in the Doors, famous rock and roll group that he founded, then transferred to the girlfriend's parents. Okay, imagine that. I'm sure Jim Morrison, in a moment of sobriety, did not intend that the girlfriend's parents would own the rights to the Doors and the music and so forth. Jim's parents disputed the estate going to the girlfriend's parents, and her parents ultimately agreed to provide Jim Morrison's parents with half of the estate. What's the moral of this story? Do planning, okay? We never know when we're going. We never know when we're getting in a car accident. We never know when we're having a heart attack. We don't know. We need to plan. Plan for the future. Prince, okay, another obviously big rock and roll star. Prince, songwriter, Purple Rain, Little Red Corvette. He died in 2016 from yet an accidental drug overdose at the age of 57. Shock of all shocks, he had no will, okay? Scores of claims were filed by people claiming to be Prince's heirs, okay? Heirs, H-E-I-R-S, is a relative. Typically, heirs go down in the tree, meaning they're children, but often they go across siblings. Sometimes they go up if your parents are still alive. Sometimes they go down when cousins come out. So, the court determined that his estate was to be divided among 6 sibling heirs, and one heir died, opening his estate to parties not related to him, as a result of the heir's will. So at the end of the day, this is a scenario, again, that could have been avoided. Prince could have decided to write a will, but I suspect that when you're at the top of your game in a rock and roll scenario, estate planning never even enters your... Philip Seymour Hoffman. Philip Seymour Hoffman, Academy Award actor. He died in 2014, $35 million, a $35 million estate. I guess it pays to be a successful actor or a rock and roll guy. And Hoffman's will was executed in 2004 when he only had one child. His outdated will didn't provide for his two younger children, which means, okay, if he writes a will, leaves to one child, and the afterborn children, the children born after he writes that will, they're left out. They're totally in dire straits. They don't inherit. And they have to file a will contest. They have to file a court proceeding, inherit their father's assets. Solution? He could have updated his will pretty easily with what's called a codicil, an amendment to a will, to add, or his will could have been written to say, all of my children, whenever born, things of that nature, that could have taken advantage of some of the loopholes that exist. Those two kids are in dire straits. They don't inherit from dad without a court battle. TV series ER, pretty famous show. Park. Clayton leaves behind a messy estate because he fails to update his estate planning to provide for his son. Born when he dies at the age of 6. So clearly, the mother of the child was pregnant and didn't do anything about it. But of course, again, when you don't know in terms of what the future holds, this man's maybe it didn't. Water from a marriage objected to that child receiving a share, even demanding a provision in this will for any of my heirs or relatives mentioned or may be determined to be except as mentioned in the because that it's in a clause. Franklin is from pancreatic with an estimated estate $17. The estate was enforced in wills, and yes, you can write a handwritten will at your own risk here in Illinois. It's allowed. I've never seen a handwritten will effective or work in a courtroom scenario, in a probate scenario. But she had 2 handwritten wills found, guessed, under a couch cushion in her house. Okay, not with lawyers, not in a safety deposit box, under a couch cushion. Family feud over the handwritten wills to determine their validity. The control over the estate ends in July of 23. Again, she died in 2018, okay? When a jury decides that the 4-page hand-scrawled document was really her will. So that's a pretty interesting one. We don't see a lot of handwritten wills, but again, those that we see are always non-compliant with. James Gandolfini. Everybody knows the guy from The Sopranos. I forget what character he played, but he was a lead character. And he dies of a heart attack at the age of 51. And man, he made a lot of money. Estimated $70 million. So the Sopranos were pretty good to him. And his will leaves about 80% of his estate exposed to taxes. They had to pay about $30 million. Okay? Now, there are legitimate methods of avoiding that kind of tax bite. You don't have to have $70 million to legitimately avoid federal estate taxes and state of Illinois inheritance tax. But look at those numbers. Can you imagine? The kids are expecting to get 70 million, and they're left with roughly 40. Nobody's got a crying towel for them, but 30 million in taxes is a lot of money. Tom Petty, singer-songwriter, lead singer of Tom Petty and the Heartbreakers. Yet again, another slide, accidental drug overdose. I think that the music industry and drugs probably go hand in hand. And Petty dies, and there's a dispute between his wife and the daughters from a previous marriage over trust language and the handling of Petty's artistic and intellectual property. Ultimately, the case is settled out of court for approximately $5 million. Sonny Bono. Everybody thinks, I think, frankly, Sonny Bono is only famous because of his wife, Cher. And, Sonny Bono dies way back in 1998 of a skiing accident, leaves an estate behind of approximately $2 million, no estate planning. His then wife marries, appointed administrator. Cher, the famous member of the couple, files a lawsuit for approximately $1.6 million. He didn't pay her out of their divorce. A man files a lawsuit claiming to be, notice the language, Sonny's love child before dropping the case when asked to provide DNA. And there are a lot of disputes. Yet another kind of absurd scenario that could have been avoided with appropriate planning. Robin Williams, I think everybody knows about Robin Williams, mostly probably from Mork and Mindy, and of course the movie Mrs. Doubtfire. Regrettably, he commits suicide, and he had Lewy body dementia, very serious illness. 3 months prior to his demise, he was misdiagnosed with Parkinson's. And nevertheless, he commits suicide. And yet another guy that did pretty well in Hollywood, over 100 million approximately. He's married 3 times, has 3 children, all named heirs. His wife, doesn't say which one wife, disputes how much money she needs to remain in the house acquired before their marriage. And she acts against his wishes by challenging his plan in public. Good morning, ladies. Welcome. Britney Spears. Britney, I think, is stunningly current and famous. After a series of events showing a breakdown in Britney's mental health, and this has been all over the paper, her father became her conservator. Here in Illinois, we call it a guardian or a guardianship. Other states call it conservatorship. Britney never wanted her father to be her conservator. She preferred a professional company, request denied for years. Finally, in 2021, the judge noted that her father no longer served her interest. And note here, her father paid himself $6 million, over $6 million for his work, more than $30 million in fees to dozens of firms for questionable work. Allegations against her father included installing surveillance equipment in her bedroom, mirroring her text and phone conversations, and the conservatorship was claimed to be to bully her for her father's gain. Finally, in November 2021, it was terminated. That got a lot of press, and I think everybody probably had heard of that one. So this is now moving from, these kind of wild and crazy stories and which are often fun to look at, but let's take it down to what does it mean to everybody in this room. And, more than 50% of Americans think estate planning is at least somewhat important, but only 1/3, 1 in 3, have trust. When asked why they don't have one, basically one out of because we don't have enough assets to leave behind. It's kind of interesting. And one advanced directive. So talk about exploitation schemes, but here don't do planning because they don't have enough assets, they believe. In Illinois, if you have assets in excess of $100,000, okay, $100,000, assets in excess of $100,000, the law requires upon your death that we open a post-death probate proceeding. And a probate proceeding is a court proceeding in which the court will take control of the distribution of your assets. If you have children or if you have a spouse, in the normal case, those assets go to that spouse. But $100,000 by today's standards is not considered a lot of money. And again, if $100,000 is in your name alone, post-death probate. Now, there's a lot of ways to avoid that. You own the assets in joint tenancy. Assets in joint tenancy are two people. I own my joint tenant hypothetically with Chris, and I die, she gets the assets, avoids probate. Excuse me. So probate avoidance is also an important part of planning if you're going to do planning at all. Advanced directives, by the way, 1 out of 5 don't know. In Illinois, we're going to talk more about this. We have 2 types of powers of attorney. That's an advanced directive. A power of attorney is a document in which you name someone to make decisions for you when you're not capable of making your own decisions. In Illinois, they come in 2 flavors, okay? A power of attorney for property, which is the management of assets, not just real estate, and a power of attorney for health care. Both critically important. Why? Because do you want to be put on life support when you can no longer make decisions regarding your health care? Do you have someone you can name to make those decisions for you that you trust and that loves you that will make those decisions? Do you have someone that can manage your assets when you're no longer capable of managing your assets? That's a power of attorney for property, okay? Very important components of an estate plan that often includes a will, maybe a living trust, and a power of attorney for health care, and a power of attorney for property. So common exploitation scams include fraudulent deeds, drafting and executing new estate planning documents when somebody perhaps is suffering from Alzheimer's disease or some form of dementia. They're unduly influenced. They're persuaded by someone to sign a new will, leaving everything to them, cutting out other people. Often we see one child persuades dad or mom to sign a new will, cutting out the other children. Very, very common scenario. The conversion or theft of money and property, and of course, construction and home repair scams that are typically done by strangers that come in and assure you that they're going to take care of repairing the house or fixing the bathroom and charge 3 or 4 times what it cost. So, common scenarios. A breach of fiduciary duty relationship, what does that mean? That means that if someone is your agent under a power of attorney for property and they steal your money, or someone's an executor of your estate and they steal your money. Breach of fiduciary duty cases, relationship cases, most commonly involve, as almost all of these do, the theft of assets. Real estate and money, stocks, things of that nature, cars, whatever is of some value. Undue influence is, as I mentioned earlier, typically when someone is cognitively impaired, someone else comes in, often a caregiver or often a quote-unquote loving family member, to persuade that individual while they are cognitively impaired to give them assets or to steal assets from them. And there's some sophisticated scams, and there's some that are not very sophisticated. Hi, Dad, my kids and I need a place to live. Will you sign this document? And it's a deed transferring the condo Dad lives in to the children or the daughter or one of the children. Caregiver exploitation, very common, as you know. Caregivers are often in the home alone with an older adult. When a caregiver is brought in, it means that older adult needs a caregiver. And typically that caregiver is brought in because the older adult has some physical issues and often has some cognitive issues. Caregivers develop relationships, they're alone in the house, and they often, I've got multiple cases in court going now in which caregivers had older adults sign documents for money, give them access to bank accounts, sign deeds to the house, sign contracts for higher pay raises, things of that nature. So it's a big problem. And of course, almost all of these involve some form of mental incapacity. Someone's diagnosed with Parkinson's disease that ultimately is affecting their cognitive ability, early onset dementia. They're in later forms of dementia or Alzheimer's disease. And again, the common thread is some type of cognitive decline. Any questions at this point? Okay. So we often, see what's really a bad scenario, spousal abuse in the elderly spouses unable to support each other in their advanced years, physical, psychological. They perhaps feel helpless, weak, may have lost some of their faculties and become ill more frequently. Resentment, finally able to enjoy retirement, and one spouse falls ill and dependent on the other. This typically occurs in a multiple marriage scenario, and it often has the kids from the first marriage fighting with often the wife of the second marriage. Dad may be elderly, may be ill, and may have died already. And multiple marriage scenarios often breed substantial disputes. So other scenarios that incur potential exploitation, recently widowed or a widow, doesn't really matter whether it's male or female. They're lonely, they live alone, they want attention from some much younger suitor. I was involved in a case recently in which an 85-year-old woman was financially abused online by an alleged lover online. She lost in excess of $100,000, believing that the person at the other end was a love interest, and we haven't yet proven it, but most of these cases involve somebody out in Africa who is doing this all day long online and coming up with crazy, crazy scenarios. But, people become lonely when their longtime companions, husbands, wives pass away. And whether it's online or in person, we see a lot of exploitation of older adults, particularly now in the romance arena. And it's very, very sad, but it's very serious for the losses that have occurred. Often people promise marriage. I was involved in a case in which 7 figures of money was sent overseas. Honey, I need plane fare. I need money to pay for my hospital bills. I need, money to come and see you, et cetera, et cetera, et cetera. Crazy scenarios that people just fall for because they're lonely. And often it involves, just change the name on the bank account, add me to the bank account. I'll have easy access to pay my bills, to come and see you, and another method of exploitation. Somebody asks you to put their name on your bank account, just tell them no. Unequivocally, 110% no. The only exception might be if you have one child and that one child it wants to help you out. But if you have 3 children and one child comes to you and says, put my name on the bank account, it's only going to lead to an explosion between the other kids. Because again, joint tenant bank accounts, A and B on joint tenancy, A dies, B gets it. You got more than one child, C and D, they're cut out. So again, I talked about it being problematic for children from the prior marriage. The multiple marriage scenarios where it's your kids, my kids, and our kids, explosion coming. You can guarantee it's going to happen. So remedies, lights, action, camera, Peck Ritchey's legal remedies, estate planning, probate avoidance, revocable trusts, powers of attorney, etc. Distribution of assets upon death is basically the idea for behind estate planning. Why do we do estate planning? We do it to distribute our assets the way we want to leave them. We do it to avoid taxes, and we do it to ensure some stability if we can. Advanced planning for the management of financial affairs in case of mental incapacity, power of attorney for property. Advanced planning for healthcare, power of attorney for healthcare. Avoidance of probate, use of a revocable living trust. We'll talk about all of this in more detail. Estate tax planning and asset protection planning. If you're planning some point, you may need government benefits to go on Medicaid. So even before the estate taxes, the goal here was for planning to protect your assets from creditors, to preserve family wealth for future generations, to provide for support and income flow to all the family, manage assets for those that can't do it, and succession business planning. So what's probate? Probate is, as I mentioned, a post-death court proceeding, typically 9 months to 2 years. All assets held in an individual's name in excess total of $100,000 go into probate. Typical costs: attorney's fees, executor's fees, court fees, potential will contests. Hey, that's not what Dad meant. He left me out of the will. I'm filing a will contest alleging Dad lacked the mental capacity to do his will, or he was undue influenced by my sister who persuaded him to leave everything to her. Example of probate: king of rock and roll. Okay? Elvis dies with assets approximately $10 million. When he died, that was a lot of money. His debts are almost $4 million. His expenses are almost $2 million. His estate taxes are in excess of $3 million. Look what he leaves to his heirs: less than $1 million. Okay? Now, we all know Elvis was too busy to do estate planning, but clearly, here's the result. So, probate avoidance mechanism, again, joint tenancy. I'm saying it probably the 3rd or 4th time. A and B. A dies. B gets the asset outside of probate. We can use it for bank accounts. We can use it for real estate. We can use it for a lot of different assets. Passbook trusts, not so common. Life insurance. If I have a life insurance up on my life and I leave it to my wife, passes outside of probate. A good device. POD, payable on death accounts. I own an account at the nearby Citibank. It's in my name. I have a beneficiary, my wife, payable on death. Avoids probate. Lifetime gifts. You might want to make a gift during your lifetime to your loved ones, your children, your grandchildren, so you can enjoy them enjoy their gift. Okay? A lot of clients come to me, oh, I got a lot of money, but I'm going to leave it to them. And honestly, I say to them, I think you should start thinking about giving them the money, okay? So that you can watch them enjoy that money. Well, I don't want to spoil them. Okay, give them less money. But let's make sure that, you're around to enjoy and they can say, hey, Grandpa, hey, Dad, thanks for the money, instead of you're 6 feet under and they're fighting over who gets it. Living trust, we'll talk about in a minute. So avoiding probate, joint tenancy, we talked about it, and joint tenancy may unintentionally disinherit other heirs. Okay, we talked about that. Again, joint tenant A and B, and you have children C and D, and B gets the money, C and D are angry. They didn't get any of the money. Unless you create another joint account, and you can, for them. Oh, so a revocable living trust. A revocable living trust is a very common estate planning device to avoid probate. And what is it? A revocable living trust is an artificial entity, a document, in which we change the title to our house. We might change the title to our bank accounts. We change the title to our stock accounts. Almost all assets other than IRAs can go into this type. There are other things. But we change the title, we put it in a revocable living trust. My trust is called the Kerry Peck Revocable Living Trust, dated whenever we sign it. And by changing the title and putting assets into the revocable living trust, we avoid probate. Again, probate, $100,000 threshold, post-death court proceeding. You saw Elvis, you don't want to be Elvis. You might want to dance like Elvis, sing like Elvis, but you don't want to be Elvis in the probate scenario. The document is private. The document can be amended anytime as long as you have the mental capacity to do so, okay? All of our estate planning requires mental capacity to do so. It avoids the need for guardians. A lifetime proceeding to determine, do you have the mental capacity to make your own decisions? How do we avoid those proceedings? We do planning. We do a power of attorney for property, for health care, to avoid a determination as to whether we can make our own decisions. While we're capable, we decide who we want to make our decisions. We don't go to court and fight over who should make the decisions. So the same document also allows for estate tax planning. Revocable living trusts have become very, very common. They are accompanied by what's called a pour-over will. Why? Because anything not in the trust, other than, again, IRAs and retirement accounts and a few other types of assets, pour over into the trust if the title hasn't been changed. But we don't want over $100,000 in assets to pour over, because it requires then a probate proceeding to take those assets and pour them into the trust. Again, a revocable living trust is like a box, okay? And what we do is we put our assets into the box. We change the title to the assets as we put them into the box. Why do we do it? To avoid a post-death court proceeding called probate. Questions? Yes?
You do a will in writing, it's usually not effective. What about if you do, I've heard of those wills that you can do online, and you include all the things that you're mentioning, making sure you put it defined, who's getting what, how it's being distributed. Is that subject to probate as well?
Well, probate determination is primarily determined by asset value, okay? So if you own $100,000 in your name alone, even if you have a will, it will require probate, okay? So don't be confused. If you have a will, think you don't have to do a post-death probate. It's the title to your assets and their value.
But if you were subject to probate, if you
No, we're kind of we're mixing apples and oranges. Okay, the most important issue in determining whether there's going to be a probate proceeding is how your assets are owned, how they're titled, Okay, Kerry Peck alone. If I have a hypothetically a bank, Citibank in $200,000 in my name alone, whether I have a will or I don't, it's going to probate. Okay, which means I need to open a post-death proceeding, and I need to file the documents to open an estate, determine who my heirs are, my closest relatives, appoint an executor or administrator, executors with a will, administrators without a will, and run the 6-month statute that creditors have, usually credit cards, mortgage companies, to file claims against my assets. So the analysis is, how are my assets titled and valued? Now, as to the question about doing your will online, it's a new thing. It sometimes works and it sometimes doesn't. Okay? Wouldn't work because it doesn't comply with Illinois law. Okay? Illinois law requires that a will be witnessed by 2 people, okay, and in general, it be notarized, okay? You can't do it. You absolutely can't do it. Here's the issue. If you do your own will, you'll never know if it's going to work because you're gone, okay? You're dead. I'm encouraging you to consider hiring a lawyer who knows what they're doing. Obviously, the prices range up from here to beyond, but I think I'm a lawyer and I do it for a living, so everybody goes, he wants to make the money. The reality here is I want to prevent your agony and your family's agony. And you're not going to know if it doesn't work. That's the reality. So there's a substantial protection element by having a lawyer who knows what they're doing do it. Yeah, so you're buying insurance. Yes.
You can avoid jumping through those hoops if you took your $200,000 account, put it in trust.
That's correct. Perfect. You got it down cold. Everybody hear what this lady said? I can avoid probate if I take my $200,000 account that was in the name of myself, Kerry Peck, alone, and I change the title and I put it in the Kerry Peck Revocable Living Trust. I now avoid probate. I don't have the expense. I don't have the delay. I don't have the aggravation. Okay? Yes.
You mentioned that the account is solely you at the bank. What if the bank also allows for where it's solely you, but there is either a beneficiary or payable on death named in the bank account? Is that also avoiding probate or not?
Did everybody hear the question up front? Okay, so it's a good question. If the bank account's only in my name, we know it's going to probate. But if the bank account has a POD, payable on death, or a beneficiary, can you avoid probate? The answer is yes, you can. Okay? Now, you should know something else about joint tenancies, though. A lot of people lose their assets to a joint tenant because the joint tenant has 100% withdrawal rights. Now, a lot of people look at me and go, Kerry, well, you know, I put my kid on. And I go, okay, that works fine. Until your kid says, hey, you know, I just met this new woman or I just met this new guy and I want to impress him. And I want to get some money to either buy something, buy a car, go to a fancy dinner, take a big vacation. Joint tenants, don't forget, have complete 100% withdrawal rights of joint tenancy assets. So it's important. Choose joint wisely. I'm not telling you to put them on. I'm telling you to choose them wisely and what they're doing, okay? Because once the money's gone, usually it's an older adult who needs that money for their care, their health care, living situation, their nursing home, things of that nature. Yes, ma'am.
There's another reason to not do joint tenancy. This is my daughter. We keep our assets totally separate because we were once told that, let's say she gets in an auto accident, they want to go after all her assets. If it's joint tenancy, they can take yours too, right?
Correct. And anybody here? Everybody here? Okay, so the question was, this is a mother and daughter sitting up front. They keep their assets separately. And the rationale, the basis for it is, if her daughter gets in a car accident, the creditors, the other car accident, the other side will try and get all of her assets. If she's on joint tenants with her mother's assets are considered her own. So it's also a method of creditor protection to keep it separate. Good point. Any other questions before we proceed? Okay. Yeah.
Having never done anything joint tenancy, are there any tax implications where you do taxes different each year? How are those assets owned if they're co-owned versus individual?
You know, it's you're going to get a 1099, but I think that they're going to probably be viewed as 50-50 in general.
There's a primary.
So the person that contributed the assets is going to get it.
Created the account. My father did that, and my name's on everything equal with his, but all the 1099s and everything on his name.
Okay.
And he paid taxes on it.
So I think the person that creates the account is going to get the 1099.
Whoever you tell,
Sorry?
who's ever Social Security, you give them when you create the account.
Yeah, when you open.
Yeah, when you open.
Yeah.
Question, we've had a problem with banks where my daughter, because I'm partially paralyzed, my daughter will go to the bank. She's my power of attorney, but they still want her to bring the signature card to me to sign it, to bring it back, which to me defeats the purpose of I'm comatose, of her being the power of attorney. So is there a difference in the way?
The question, if you didn't hear, was daughter holds power of attorney and the bank wants mom to still sign all of the transactions. The answer is every bank's got their own rules. There's no uniformity. It's a very difficult landscape to maneuver out there, and I wish I had an answer for you, but I don't.
The other thing, they won't let her, some of the banks won't let her put herself out as beneficiary. That's what I've asked to have done.
Yeah, well, that some of the banks won't let her put on as beneficiary. That's, I think, a protection for you. But we're going to move on, and we can answer some of the more questions at the end. So a revocable living trust is important. You know that it provides the creator of the trust no creditor protection. So that's important. It does provide a mechanism to manage assets for the beneficiaries and can provide creditor protection for them, not for the creator. Important. And again, it's an integral part of an estate plan. So how many people are as old as I am and remember the Doublemint twins? Yeah. So the Doublemint twins up there, this is, again, another example of understanding the power of attorney, okay? Power of attorney, again, a document you execute while you're competent, naming an agent, someone you choose, someone that loves you more than they love your money, okay? As your agent to make decisions for you when you can't make your own decisions in regards to the management of assets, called property, again, not just real estate, assets. And it's basically what I call your legal clone. Important. Oh, it's old case. Years, her family fought legally, and there certainly was a political battle over it. Whether or not she should be tube-fed, kept alive, things of that nature. It's critically important that you think about those issues. And it's critically important that you name someone that will implement your belief. Okay? In the power of attorney for healthcare, you must choose, is the length of my life more important or the quality of my life more important? Do I want to be on a nasal gastric tube which goes in my nose and keeps me alive with feedings, like Terry Schiavo? Or do I want the quality of my life to remain more important? And again, you need to choose an agent that's going to implement your wishes. Power of attorney for property. We've talked about it, and we're talking again because it's critically important. It avoids guardianship. Guardianship is that lifetime probate case. Is Kerry competent to make his own decisions? Well, you know what? I'm not worried about it. I signed the powers of attorney, and I named my agent, my people to act on my behalf, my legal clone, when I'm not capable. So I don't have to have a court proceeding to determine when I'm not capable and who should make decisions for me. So this is, you'll recall I mentioned earlier, some of these assets cannot pass by probate, but they can be managed by a power of attorney for property, your IRAs, your benefits, things of that nature. So it's important. Power of attorney for property, powers to handle income tax, estate planning, tax planning, Medicaid planning, change title to property, and property. You can get HIPAA information, primarily under power of attorney for healthcare, to make medical decisions. But you have access to bank records, things that would be important in preparation of tax returns and the like. So no power of attorney for property, you're going to have a guardianship. You're going to have that lifetime probate. Are you capable of making decisions? Are you totally incapable of making personal, which is medical, and or financial decisions, management of your assets? And a court-appointed guardian is going to make decisions consistent with the Illinois Probate Act. Okay? Down at the Daly Center, there are half a dozen approximately judges that hear guardianship cases. Does Kerry have capacity to make his own decisions? There's about the same half a dozen different judges that hear post-death probate proceedings. Was there a will? Is there no will? Who are the loved ones or heirs of the decedent when they die? Who inherits the property? Was there undue influence? Did mom or dad have the mental capacity to sign a will? Were the assets in joint tenancy? Can the spouse renounce a will? Okay, spouse disinherited, renounces the will, gets money under the Illinois Probate Act. So a lot of different post-death probate scenarios. We talked about the power of attorney for health care. Basically, gives your agent complete control to make health care decisions, on the recommendations in general of your doctor. But again, is the quality of your life or the length of your life more important to you? You need to tell somebody now why you can talk about it. So don't delay. Well, we wish everybody good health and prosperity. None of us know what the future is. We don't know if I get back on the highway and head to my next engagement, whether I'm going to make it or I'm going to get broadsided by that semi-truck. So estate planning is crucial to planning family wealth, to planning decision-making, and it's important to begin the process. Really, don't delay. We just don't know what's around the corner. So if you have a legal question involving, this type of litigation, trust and estate litigation, financial exploitation, hoarding, dementia issues, elder abuse, self-neglect, guardianship, powers of attorney, wills and trusts, probate estate administration, we can answer those questions today. You can give us a call. Our initial legal consultation is no cost, and I hope everybody's enjoyed our presentation, and if we can help you, please let me know. Yes, ma'am.
I just had a question about how does this play out when you've got property? How does it, who gets paid and which state takes
It's a problem because often residence determines primary estates, and then there's often ancillary probate proceedings in other states if there's real property,
Okay,
depending on how it's titled.
okay, if there's a trust in place,
It may cover the may cover the whole scenario, but every scenario is different.
depends on the state.
Yeah. Now,
Another question. I just want to thank Kerry Peck from Elderworks for joining us today. Thank you.
thank you. Thanks for coming out. We appreciate it. Yes, ma'am.
When you talk about the $100,000, that's including like house and car and bank.
Everything. Yeah. So it's not individual. Yes, ma'am.
What can I say to, I'm trying to get my relatives to work on either will or trust or something, but they like, I don't have anything, but they're not recognizing that they have a house. And it's a house in California, so.
Yeah. For real estate in California is expensive, and the answer is avoid later problems that are going to be more expensive than doing it now. That's really that's all I can tell you, because that's what's going to happen.
Yeah, I'm trying to get it.
Yeah. Thanks for coming. Oh, thank you.